the premeditation part is going to be a big part of this, right? Did he have this plan hatched before the officer came up to the car and all of that? How do you poke holes in that as a defense attorney throughout this without offending intelligence and feelings? Because people, this has been teed up by the prosecution beautifully. Let's face it, these jurors are likely team prosecution right now. How do you do it?
Right. A couple things. Number one is they're doing the right thing, okay? Being respectful to the jury and showing them the level of respect that you extend, especially when you're talking about things that are maybe sometimes hard to swallow. These are very important things so that you don't lose the jury. If the jury thinks that you're a jerk, they're just not going to like your case. And so essentially, I think that they're taking the right steps. Now, there is a pathway here for Wiggins. There is a pathway for lesser included offenses. I think that you could use, maybe his mentor. I want to see how they use the experts for his advantage, and to show and challenge, death penalty. If we're saying, well, we're really at the sentencing phase, well, use sentencing laws to your favor, to your client's favor, and find ways to take him out of the running for the death penalty. So I don't think that this is deadlock. It's over for Wiggins. I think that there's a pathway for it, and I think that his lawyers are doing it correctly. They're being respectful to the system. They're being respectful towards the victims. They're acknowledging that there was a wrong. They've owned up to it right in closing arguments. And the way that they present their case in chief is going to be monumental in what is the outcome for this defendant.